How's everybody doing today? Our topic today is protecting yourself against negative custody tactics. It's sad to say, but custody and divorce bring out the absolute worst in some parents. And instead of thinking about what's in the best interest of their children, many parents instead decide to go after to try to smear or discredit the other parent, regardless of the consequences to the children. Now, here are some of the more common tactics that are used to obtain custody, and we're not recommending these, we're just telling you what to look out for and how to defend yourself. First is domestic violence allegations. Next is move-away requests, involving Children's Protective Services, false allegations, allegations of substance abuse, minor custody violations, and parental alienation. Now, I've said previously in the other sections, and we'll say it again, always take the high road. Avoid doing anything negative or potentially damaging to your child, but you have to be aware of these tactics and what to do in case you're falsely accused, because unfortunately it happens quite often. There will be another section on parental alienation later on, so we'll talk about that specifically, but not right here. Okay, first let's talk about domestic abuse and violence. Accusations of domestic violence and abuse have become so prevalent in custody cases that it's become known as the silver bullet. Now, I'm combining them together for the impact, outcome, and the way the court views them, which is comparable. So if you make an accusation of domestic violence or abuse against your spouse during custody, you're immediately going to have a huge advantage. It's even listed as a tactic in books such as Divorce for Dummies by John Ventura and Mary Reed, which is actually pretty horrible, but it's the reality. Now, courts take allegations of domestic violence in child custody cases very seriously. There's always the concern that if the court does not take strong action, the accused parent could end up harming the child later on, and the court does not want to be involved in that or potentially responsible because it's something they missed. So for this reason, courts tend to be very conservative when it comes to granting custody or visitation following accusations of abuse. At absolute minimum, it's going to drag things out, assuming there's no validity to the claim. And it's going to give the other person, the person making the allegation, initially, it's going to give them an advantage. Now, long term, it may hurt them when they find out the allegation is without merit. And the reality is, at least 3 million children witness acts of domestic violence annually. Domestic violence in relationships is often the catalyst for one spouse to file for divorce and leave a relationship. So if there are children involved, the issue of child custody then arises. And in such cases, the courts have to determine which parent will be granted physical custody of the children: the alleged abuser, the alleged victim of the domestic violence, or both. And ultimately, it's the court's responsibility to consider the best interest of the child. So regarding incidents of domestic violence in custody cases, it's important because they're going to defer to what's best for the child's well-being and safety. So even if there's nothing there, it's going to have an impact. Now, the court's always going to consider evidence of recent and long since past accusations of domestic violence, and these are regularly considered in child custody determinations. And the court may deny custody to a parent who's been accused of domestic violence if it determines that the parent poses a threat to the child or the child's other parent, the victim. Now, the problem is that not all accusations of domestic violence are true. Many of them are not, and they come up for the first time in the context of a divorce. And while the courts aren't stupid, once again, they still have to take it very seriously. It's especially true when there's no history of domestic violence prior to the time leading up to the separation. So it's like, wow, there never has been before, and all of a sudden there has been. But once again, they still have to take it seriously. Now, in general, judges are going to consider the alleged instances of domestic violence, what the effect it's had on the child, what the effect it's had on the other parent, whether the accused continues to pose a danger to the child or to the other parent, the severity and frequency of the domestic violence, which courts may now consider to be a strong indicator of future behavior, whether there's a pending criminal case against the accused, any physical evidence of abuse, including photographs, police reports documenting incidents of alleged abuse, and incidents of violence. They don't just impact child custody determinations. They also determine whether the accused will have access to visitation. Now, the court may choose to revoke the accused parent's visitation rights, either temporarily or long-term. They may order supervised visitation. They may revise the accused parent's existing visitation schedule, for example, revoking overnight visits. They may order parenting classes or anger management classes. They may order the accused parent to participate in domestic violence counseling. Or they may issue a restraining order or some other sort of order of protection. Okay, the next tactic is move-away requests. These are especially prevalent if they have sole legal custody, because it's very tough to defend against that. But even if it's joint physical custody or joint legal custody, this still can happen. And when child move-away cases come up, they can be really damaging emotionally and really expensive. So whether you're the one seeking to move away or the one opposing it, most experienced custody lawyers will tell you that move-away cases are some of the most emotionally difficult for divorce and family law clients, because this is where you really rip the other parent apart, taking the child away from them completely. Now, more than perhaps any other area of family law, move-away cases usually involve a bitter division between the parents. The parent who seeks moves to look at the challenge to start a new life somewhere else, while the parent who is opposing the move vows to fight till the end to keep the children from leaving. Now, parental relocation clauses are extremely important to consider. According to Vijay Sharma, approximately 17 to 25% of divorced parents will relocate within 1 year of being divorced. Parental relocation is one of the top reasons that divorced parents return to court year after year. Furthermore, parental relocation can have drastic effects on the child's quality of life if it interferes with their ability to engage in the same extracurricular activities that their peers growing up in nuclear families might have been able to participate in. Now, a move away is a serious disruption of most child custody schedules, and having a stable and continuous custody arrangement is one of the most important factors in any custody case. Whenever courts are in doubt as to what custody arrangements are best, they look for the status quo as a fallback, if it's been working, which makes sense, even if it hasn't been working perfectly. But as long as it's been working well enough for the children, this is what they're going to look at. So move-away cases that are the most disruptive to the status quo is the rare instance when the parents can maintain the same visitation schedule if one parent seeks to move out of or to another part of the state. So, how does sole custody versus joint physical custody factor into move-away cases? First, the attorney has to look at whether or not the parent who wants to move has sole custody or joint physical custody of the child. If there's already been a final judgment of custody, where was I? If there's already been a final judgment of custody in the case, the parent who seeks to move has been given sole physical custody, then the non-custodial parent who wants to avoid the move away generally has the initial burden to show that the move away would be a detriment to the child. Now, that's because the parent who has sole physical custody is presumed to be able to relocate with the children as long as they give proper legal notice to the other parent of their intent, although there have been many exceptions to this rule in certain cases. Now, what happens if the court does not allow a move away, absent written agreement or further order? In such a situation, the parent who proposes the move away must file a formal request with the court to obtain a move away order. The non-custodial parent still has the initial burden to show a detriment to the child with regard to the proposed move if there's been a final judgment and the parents don't have joint physical custody. Now, if parents share joint physical custody, then a careful analysis should take place as to whether or not the move is in the best interest of the child. Family law judges look at the best interest standard with fresh eyes and assume that the parent who requests the move really does not intend to move away with the children. Now, if the move away is denied, the judge cannot assume that the requesting parent will stay. So parents think if their move away is denied, it's no big deal. They'll just change their mind. It usually doesn't work that way, so that's why this is a really dangerous strategy. So if you decide, I want to move away with the child, and the judge says no, oftentimes they're going to change physical custody or possibly even legal custody to the other parent. Now this is because the court generally doesn't assume the parent will stay if the judge, and they specifically started for the parent proposing to move, that they better know what they're asking. So once again, know what you're doing. You don't bluff on this, or you don't, if they say yes, I move, or if they say no, I don't. It's going to affect you either way, so you do not want to enter into this lightly. Because once again, the judge denies the move, then the judge is going to give custody to the other parent. So think twice first. Now the complexity and sometimes confusion over such issues highlights one point. It's critical that the attorney educate their client that seeks the move away, because if the move away is denied, there could be a change in custody. Even if sole physical custody of the children is maintained by that parent requesting the move away, once again, this can change. So I can't stress this enough. You don't want to request the move away unless you are absolutely sure you're going to do it with or without the child, and you're okay losing the child if you do. But if you think, well, I kind of feel like moving, I'm going to see what the judge does on this, horrible, horrible idea. Now, in addition, the law in move-away cases can and does change. Courts don't enact laws, but they do interpret them and how they should be understood and applied. And that's also why seeking the advice of a family law attorney is important, because the laws are constantly changing. So, how important are the labels of joint custody and sole physical custody in the court order? What actually qualifies as joint custody versus sole custody? We talked about this in another section, and if you need a refresher or if you haven't seen it, please go look at that. Is it enough that a custody judgment simply lists the parents as having one or the other? And the short answer is no. Labels in custody judgments are not final or determinative as to whether or not the parents have joint or sole custody. Courts focus on the actual timeshare with the children, regardless of what the custody judgment says, which is good news. So, what happens when there's not been a final custody order and that one parent seeks a move away? In that situation, the court simply uses the best interest of the child standard and does not presume anything for or against either parent when determining whether a move away should be allowed. However, the courts will still proceed as if the parent that requests the move away actually intends to do so. Clear? If not, as always, feel free to email me and I'll be happy to answer this for you or provide additional color. Because we're moving on now. Children's Protective Services. Children's Protective Services should be there to protect the children. Unfortunately, sometimes the other parent will threaten filing a complaint with Children's Protective Services. And this is a serious problem, as their complaint, even if it's completely unfounded, the court's going to take it very seriously. So, if you're doing your best to be a good parent, you should not let threats undermine your resolve as a parent. Luckily, there are penalties for false reporting. Approximately 29 states carry penalties in their civil child protection laws for any person who willfully, intentionally makes a report of child abuse or neglect that the report knows to be true. The reporter knows to be true. The person making the report, not the court reporter. Those states are Arizona, Arkansas, California, Colorado, Connecticut, Florida, Idaho, Illinois, Indiana, Iowa, Kansas, Kentucky, Louisiana, Maine, Massachusetts, Michigan, Minnesota, Missouri, Montana, Nebraska, North Dakota, Oklahoma, Rhode Island, South Carolina, Tennessee, Texas, Virginia, Washington, and Wyoming. Now, in New York, Ohio, Pennsylvania, and the Virgin Islands, making false reports of child maltreatment is made illegal in criminal sections of the state code. There are 19 states in the Virgin Islands that classify false reporting as a misdemeanor or a similar charge. Those are Arizona, Arkansas, Colorado, Indiana, Iowa, Kansas, Kentucky, Louisiana, Michigan, Missouri, New York, North Dakota, Ohio, Oklahoma, Rhode Island, South Carolina, Virginia, Washington, and Wyoming. Now in Florida, Illinois, Tennessee, and Texas, making a false report is a felony, while in Arkansas, Indiana, Missouri, and Virginia, a second or subsequent offenses, they become upgraded to a felony. In Michigan, false reporting can be either a misdemeanor or a felony, depending on the seriousness of the allegation alleged in the report. Now, no criminal penalties are imposed in California, Maine, Minnesota, Montana, and Nebraska. However, immunity from civil and criminal actions provided to reporters of abuse or neglect is not extended to those who make the false report. In South Carolina, in addition to any criminal penalties, the Department of Social Services may bring civil action against the person to recover the costs of the investigation and any proceedings related to the investigation. 11 states and the Virgin Islands specify the penalties for making a false report. Connecticut, Florida, Louisiana, Massachusetts, Michigan, Oklahoma, Rhode Island, South Carolina, Texas, Wyoming, and Washington. Now, upon conviction, a reporter can face jail terms ranging from 90 days to 5 years, fines ranging from $500 to $5,000. Florida imposes the most severe penalties. In addition to a court sentence of 5 years or $50,000, the Department of Children and Family Services may fine the reporter up to $10,000 in 6 states. The reporter may be civilly liable for damages caused by the report. False allegations. Oftentimes, there'll be a variety of false allegations, and the severity of the allegation will determine your response. For anything that does not involve the police, abuse, or children's protective services, the best response is to simply state that is not accurate. If they want to push the issue, then it will shift the burden of proof onto the accusing party. If the court wants to hear more about it, they will ask you. But in general, the judge or commissioner does not want to get involved in he said, she said, especially on matters that do not directly impact the best interest of the child. So, if your spouse or ex said, oh, he did this and he did that, but they never bothered filing a report about it, the court's not going to take it very seriously. So, just say this is not accurate. You don't want to get into defending yourself and creating something that the court's probably not going to care about. If it were that serious, they would have filed a report. You may still have to deal with it, but your initial response should just be, that is not accurate. If the court wants more information, they'll ask you. All right, substance abuse. If neither parent has a history of substance abuse, it will most likely to be brought, if either parent has a history of substance abuse, it will most likely be brought to the attention of the court. It should be documented. If the court believes there's some merit to the claim, they may order testing for either once, a one-time, or on a continual basis over time. Minor custody violations. Situations may arise when the other parent does not abide by the custody agreement. Once again, depending on the severity of the violation, you may determine the best course of action. The court does not want either of you taking up court time for minor issues. And running back to court for every minor violation is absolutely not going to win favor for you with the judge. In fact, you're really going to upset them, and you're likely to incur their wrath. It's better to document all violations and then present them to the judge when you have an existing court date. Keep track, once again, if they're minor. Make sure, however, that you get it on the agenda as to when you have the hearing, and that's part of the purpose. Because when you have a hearing, if you're there for one thing, you can't just say, oh, and by the way, this, that, and the other thing. They won't listen to that. Whatever you have on the agenda is what the court will listen to. So it's not your opportunity to speak everything on your mind. All right. Now, what are some guidelines for combating negative tactics? If you're fighting a custody battle with someone who's using negative tactics, here are a couple of ideas that might help you. First is document as much as possible. Keep a journal of everything that happens. When people are lying, they should not be able to document it. When they fail to have detailed records, the court takes notice. Also, sometimes we're so busy that we may not be able to remember every detail of what happened. Keeping a journal will be important when it'll help you tell a cohesive story about what's going on, especially if you have to tell it long after it's transpired. Save every scrap of paper, every email, every text, every receipt, and develop a way of organizing the information. Whether chronological by topic, it's always good to have a binder or a file and just keep copies in a safe place. Next, have witnesses. It's best not to deal with chronic liars alone. Otherwise, every interaction that becomes he said, she said. Have a trusted friend or relative present during child exchanges or other interactions, whenever it's possible. You may even want to consider recording or videotaping some of what goes on. However, be aware, the rules to videotape and recording without consent, so it will not be admissible in court, but still it can be used to help you in different ways. 3 is, get your own information. Don't allow the other parent to control information about your children. Make sure you get information directly from schools, doctors, dentists. Make sure you're involved in the process. Also, hire an experienced, competent attorney. Once again, we'll talk about how to hire a good attorney in another section, but make sure you have one. Child custody cases with negative tactics are complicated. The other parent may not play by the rules, and your attorney has to understand this. The other parent may lie in court, and although his or her performance will appear heartfelt and like they're just concerned for the welfare of the children, they may make outrageous accusations. They're also likely to retain an aggressive attorney. Therefore, your attorney has to have experience in dealing with such situations. Don't allow lies to become part of the court record. Any parent lies, and they may do so convincingly. So don't allow it to go unchallenged and become part of the court record. Once they are, it's considered the truth, and it may put you in a very bad position. Some lies, especially the big ones, like of child abuse, may haunt you forever. Next, if you're not a licensed therapist, don't pretend to be one. Don't accuse the other person of being a sociopath, having a personality disorder, etc. Let the facts speak for themselves. Stay in your lane. If you truly believe they have psychological issues, then have a licensed professional test them and document it. A good custody evaluator should be able to see through the facade of many disingenuous tactics, of focus on proving the behavior. But if you're not a psychologist, don't pretend to be one. Another thing, I shouldn't even have to say this because it's fairly obvious, but stay calm in court. You must be present. You must present a clear, professional image when you go to court. Be involved, be conscious, but be professional, calm. Even if the other parent lies or distorts the truth, you'll get your chance to refute it, but do it in a calm way. Don't let the allegations for the other parent, no matter how outrageous, lead you to making an emotional mistake or an emotional scene. The other parent may accuse you of being unstable, and you might just confirm it by your behavior in court. Keep your emotions in check, at least in front of the judge and the evaluator. Make sure court orders are explicit. Insist on having detailed court orders. The order should not say, and this is for a parenting plan or a custody agreement, parent has visitation every other weekend. It should specify exactly which weekends, starting at what time, returning at what time, who's responsible for transportation of the child, who's responsible for bathing and feeding them, who's responsible for homework. Everything should be spelled out in detail. If there's any ambiguity, the other parent may exploit it or use it to create confusion. So, once again, you need to have this clearly written and has to be detailed. Okay. You also make sure the other parent abides by their court orders. If the other parent fails to honor the order, document it and report it at the appropriate time. Record any violation, call the police if necessary, continue to document everything that happens. because you may need to go to court again, and if you ever decide that you need to change the custody order, you're going to need evidence to do it. And finally, take care of yourself. You're going to need all your resources to deal with these negative tactics. Therefore, make healthy decisions in your own life. Eat right, avoid drugs and alcohol, get enough sleep, exercise, and develop a support network of people you can talk to, people who can help you, people you can use as a sounding board. Because once again, you don't ever want to say negative things about the other parent, to the judge, in front of your children, to the evaluator. You have friends, if you have a bartender, anything, but have a good support network. Remember, it's going to be a long road and a test of your physical and mental stamina, but there is a light at the end of the tunnel. So take care of yourself especially when you're dealing with these horrible negative tactics. If you have any questions, as always, feel free to email me. This is Joe Pastore with Platinum Method Coaching, and I look forward to seeing you next time. Until then, make it a great day.